In episode 4 of the Supreme Court Opinions Read podcast, I will be reading the Supreme Court's opinion in EMD Sales Inc. versus Carrera. The case was decided January 15th, 2025. And as always, we begin with the syllabus. In 1938, Congress enacted the Fair Labor Standards Act, guaranteeing a federal minimum wage for covered workers, 29 U.S.C. Section 206A1. And requiring overtime pay for those working more than 40 hours per week, Section 207A1. Congress exempted many types of employees from the FLSA's overtime pay requirement, including outside salesmen who primarily work away from their employer's place of business, Section 213A1. The law places the burden on the employer to show that an exemption applies. Petitioner EMD distributes food products in the Washington, D.C. area and employs sales representatives who manage inventory and take orders at grocery stores. Several sales representatives sued EMD, alleging that the company violated the FLSA by failing to pay them overtime. EMD argued that the sales representatives were outside salesmen and therefore exempt from the FLSA's overtime pay requirement. After a bench trial, the district court found EMD liable for overtime because EMD did not prove by clear and convincing evidence that its sales representatives were outside salesmen. On appeal, EMD argued that the district court should have used the less stringent preponderance of the evidence standard instead of the clear and convincing evidence standard. Applying circuit precedent, the Fourth Circuit disagreed and affirmed the district court's judgment. Held, the preponderance of the evidence standard applies when an employer seeks to demonstrate that an employee is exempt from the minimum wage and overtime pay provisions of the FLSA. Part A. When Congress enacted the FLSA in 1938, the preponderance of the evidence standard was the default in American civil litigation, and it remains so today. In civil litigation, the court has deviated from this default standard in three main circumstances. First, if a statute requires a heightened standard of proof, courts must apply it. See, for example, Section 218CB1 and Section 464C. Second, the Constitution can mandate a heightened standard of proof. See, for example, New York Times Company v. Sullivan and Addington v. Texas. Third, in certain rare situations involving coercive government action, such as taking away a person's citizenship, a heightened standard may apply. See Nishikawa v. Dulles. But in most civil cases, including employment discrimination cases under Title VII, the court has consistently applied the preponderance standard. See, for example, Prince Waterhouse v. Hopkins. Part B. The FLSA does not specify a standard of proof for exemptions, and when a civil statute is silent, courts typically apply the preponderance standard. See, for example, Grogan v. Garner. This case does not involve constitutional rights that would require a heightened standard, nor does it involve the government taking unusual coercive action against an individual. FLSA cases are similar to Title VII employment discrimination cases, where the court has applied the preponderance standard. Part C. The employees' policy-laden arguments for a heightened standard are unconvincing. Their argument that the FLSA protects the public interest in a fair economy does not necessitate a heightened standard. Other workplace protections, like those under Title VII, also serve important public interests but are subject to the preponderance standard. The employees argue that rights under the FLSA are non-waivable and therefore different from other rights subject to the preponderance standard. But waivability of a right does not determine the standard of proof. Part D. Whether the employees would fail to qualify as outside salesmen even under a preponderance standard is left for the Court of Appeals on remand. Now on to the opinion. Justice Kavanaugh delivered the opinion for a unanimous court. The Fair Labor Standards Act of 1938 requires employers to pay their employees a minimum wage and overtime compensation, but the act also exempts many categories of employees from the minimum wage and overtime compensation requirements. The dispute here concerns the standard of proof that an employer must satisfy to show that an employee is exempt. The usual standard of proof in civil litigation is preponderance of the evidence. A more demanding standard, such as clear and convincing evidence, applies only when a statute or the Constitution requires a heightened standard or in certain other rare cases, such as when the government seeks to take unusual coercive action more dramatic than entering an award of money damages or other conventional relief against an individual. None of those exceptions applies to this case. Therefore, the preponderance of the evidence standard governs when an employer attempts to demonstrate that an employee is exempt. Part 1, Section A. In 1938, Congress passed and President Franklin Roosevelt signed the Fair Labor Standards Act. The act guarantees covered workers a federal minimum wage, see 29 U.S.C. Section 206A1. The act also generally requires overtime pay when a covered employee works more than 40 hours per week, see Section 207A1. But Congress recognized that a minimum wage and overtime pay would be impractical or inappropriate for some jobs, so the act exempts many categories of employees from the minimum wage requirement and exempts many more from the overtime pay requirement. See Sections 213A through B. Exempt employees can range from baseball players to seamen to maple syrup processors to software engineers to firefighters and so on. The law places the burden on the employer to show that an exemption applies. See Corning Glassworks versus Brennan. The exemption relevant here encompasses anyone employed in the capacity of outside salesman. Section 213A1. An outside salesman primarily makes sales and regularly works away from the employer's place of business. Section B. EMD distributes international food products in the Washington, D.C. metropolitan area. EMD employs sales representatives who manage inventory and take orders at grocery stores that stock EMD products. Several EMD sales representatives sued the company in the U.S. District Court for the District of Maryland. They alleged that EMD violated the Fair Labor Standards Act by failing to pay them overtime. EMD did not deny that the employees worked more than 40 hours per week without receiving overtime pay, but EMD argued that the employees fell within the Act's outside salesman exemption. Following a bench trial, the district court concluded that EMD failed to prove by clear and convincing evidence that the employees qualified as outside salesmen. The court found that the employees primarily executed the terms of sales already made rather than making new sales themselves. The court therefore ordered EMD to pay overtime wages and liquidated damages. On appeal, EMD contended that the district court should have applied the less stringent preponderance of the evidence standard rather than the clear and convincing evidence standard. The U.S. Court of Appeals for the Fourth Circuit disagreed and affirmed the judgment of the district court. The Court of Appeals followed circuit precedent requiring employers to prove the applicability of Fair Labor Standards Act exemptions by clear and convincing evidence. Although the three-judge panel suggested that the full court might want to reconsider that precedent en banc, the court later denied en banc review. The Fourth Circuit stands alone in requiring employers to prove the applicability of Fair Labor Standards Act exemptions by clear and convincing evidence. Every other court of appeals to address the issue has held that the preponderance standard applies. This court granted certiorari to resolve that conflict. Part 2, Section A. In 1938, when Congress enacted the Fair Labor Standards Act, the established default standard of proof in American civil litigation was the preponderance of the evidence standard. The court's cases predating the act recognized as much. See United States v. Reagan and Lilienthal's Tobacco v. United States, as did predominant treatises. Since then, the predominance of the evidence standard has remained the default standard of proof in American civil litigation. That default makes sense. The preponderance standard allows both parties in the mine run civil case to share the risk of error in roughly equal fashion. In civil litigation, this court has deviated from the preponderance standard in three main circumstances. First, courts must apply a heightened standard of proof if a statute establishes one. For example, various provisions of the United States Code, including some involving labor and employment, designate clear and convincing evidence as the applicable standard of proof. See, for example, 29 U.S.C. Section 218 CB1, Section 464C, and Section 722A3A2. The same can be true when Congress uses a term with a settled common law meaning that itself requires a heightened standard of proof. See, for example, Microsoft Corporation versus I4ILP. Second, courts likewise must apply a heightened standard of proof when the Constitution requires one. For example, the court has mandated a clear and convincing evidence standard in certain First Amendment cases. See, for example, New York Times Company versus Sullivan and Gertz versus Robert Welsh Incorporated. The court has also held that the Due Process Clause necessitates a heightened standard in some cases. In Addington versus Texas, for example, the court ruled that involuntary civil commitment constitutes such a significant deprivation of liberty by the government that due process requires the state to justify confinement by proof more substantial than a mere preponderance of the evidence. And in Santosky versus Kramer, the court held the same with respect to the government's termination of parental rights. Before a state may sever completely and irrevocably the rights of parents in their natural child, due process requires that the state support its allegations by at least clear and convincing evidence. Third, under this court's precedents, a heightened standard of proof may be appropriate in certain other uncommon cases. These cases ordinarily arise when the government seeks to take unusual coercive action more dramatic than entering an award of money damages or other conventional relief against an individual. For example, the court has held that the government must satisfy a clear and convincing evidence standard in order to take away a person's citizenship. See Nishikawa versus Dulles and Schneiderman versus United States. Importantly, the court has not otherwise used a heightened standard in civil matters. Most relevant here, the court has applied a preponderance standard in Title VII employment discrimination cases. Section B. We conclude that the default preponderance standard governs when an employer seeks to prove that an employee is exempt under the Fair Labor Standards Act. First, as the employees acknowledge, the Fair Labor Standards Act does not specify a standard of proof for the Act's exemptions. Faced with silence, courts usually apply the default preponderance standard. Statutory silence is generally inconsistent with the view that Congress intended to require a special heightened standard of proof. Second, as the employees recognize, this case does not implicate any constitutional rights that might require a heightened standard. Third, this is not a case where the government otherwise seeks to take unusual coercive action against an individual. Cases under the Fair Labor Standards Act are more akin to Title VII cases where the court has held that a preponderance standard applies. If clear and convincing evidence is not required in Title VII cases, it is hard to see why it would be required in Fair Labor Standards Act cases. Part 3. We are not persuaded by the employee's policy-laden arguments for a heightened standard when an employer seeks to show that an employee is exempt. The employees contend that the Act focuses not on the individual's interest in damages, but rather on the public's interest in a well-functioning economy where workers are guaranteed a fair wage. But that premise, even if accepted, does not demand a heightened standard. After all, other workplace protections that vindicate important public interests remain subject to the preponderance standard. Eradicating discrimination from the workplace is undoubtedly important. Yet, as explained above, this court has held that a preponderance standard is appropriate for Title VII cases. See Prince Waterhouse v. Hopkins. In addition, the public interest in Fair Labor Standards Act cases does not fall entirely on the side of employees. Most legislation reflects a balance of competing interests, so it is here. Rather than choose sides in a policy debate, this court must apply the statute as written and as informed by the long-standing default rule regarding the standard of proof. Next, the employees contend that the minimum wage and overtime pay rights conferred by the Fair Labor Standards Act are not waivable and are therefore distinct from other rights subject to a preponderance standard. But the waivability or lack thereof of a right does not dictate the applicable standard of proof. Consider the criminal process. Even though a prosecution must meet a high standard of proof beyond a reasonable doubt, criminal defendants may waive their right to trial by pleading guilty. At the same time, some rights that are not waivable are subject to the preponderance of the evidence standard. For example, certain rights conferred by the National Labor Relations Act are not waivable. Yet employers may prove affirmative defenses to those rights by a preponderance. See NLRB versus Transportation Management Corporation. As those cases illustrate, the waivability of a right and the standard of proof are two distinct inquiries. Therefore, although at least some Fair Labor Standards Act rights are not waivable, it does not follow that a heightened standard of proof must apply when an employer attempts to show that an employee is exempt. Finally, the employees assert that a heightened standard should govern in Fair Labor Standards Act cases because the employer controls much of the evidence relevant to establishing a violation and because plaintiffs in those cases may have low incomes. But in Title VII cases too, employers control most of the cards, and plaintiffs may be low income. Yet the preponderance standard applies in those cases. So too here. We hold that the preponderance of the evidence standard applies when an employer seeks to show that an employee is exempt from the minimum wage and overtime pay provisions of the Fair Labor Standards Act. The employees argue that we should still affirm because they would not qualify as outside salesmen even under a preponderance standard. But our usual practice is to leave matters of that sort for remand. We see no persuasive reason to stray from that usual practice here. We therefore reverse the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch, with whom Justice Thomas joins concurring. Sometimes the Constitution or Congress provides a particular standard of proof. If not, courts must find one. As in other contexts, they do so by examining the legal backdrop against which Congress has legislated. See, for example, Dixon versus United States and Astoria Federal Savings and Loan Association versus Salamino. In civil cases, those background legal principles typically require proof by a preponderance of the evidence. Occasionally, though, the default common law rule provides instead for a heightened standard of proof. Either way, courts apply the default standard unless Congress alters it or the Constitution forbids it. See, for example, Octane Fitness LLC versus Icon Health and Fitness Incorporated. To do otherwise would be to choose sides in a policy debate, rather than to declare the law as our judicial duty requires. Our decision today is consistent with this understanding, and I am pleased to join it. And that is it for the opinions. Once again, a unanimous opinion, and in this case, a quite short one, although we did have a concurrence by Gorsuch joined by Thomas. Interestingly, the concurrence doesn't seem to add a whole lot, although it does seem that Gorsuch and Thomas want to sort of voice a slightly different understanding of how the court determines the standard of evidence in civil cases than Kavanaugh and the rest of the court voiced in the majority opinion. The majority says, the default rule in civil cases is preponderance of the evidence, and there are three sort of categories of exceptions. One, the statute requires a different standard. Two, the Constitution requires a different standard. And interestingly, they cite New York versus Sullivan, which I believe Justice Thomas is not a huge fan of. And the third category is sort of a more nebulous category, in which the government is seeking to engage in, sort of uncommon coercive activity like civil commitment or revocation of parental rights or something like that. And Justice Gorsuch and Thomas in the concurrence sort of drop that third category. They say, no, there's two situations, two sort of categories in which the default rule is, or which we deviate from the default rule. The statute requires it or the Constitution requires it. And I think they sort of conceive of that third category not as, a third distinct category. But they say the default is preponderance of the evidence unless there's some other common law rule that requires a heightened standard, right? And then that, the sort of default as modified by the common law is what Justice Gorsuch and Thomas sort of conceive as what courts should default to unless you've got the statutory or constitutional exceptions. At least that's how I'm kind of reading this. It seems to me the only reason that this concurrence exists is to sort of lay out that understanding as slightly different from how Kavanaugh and the majority conceive of it. But other than that, as the concurrence says, the decision is perfectly consistent with that understanding, and so they just joined it in full. And yeah, as for the decision itself, it seems correct to me. The default is preponderance of the evidence. There's nothing in the statute or the Constitution that would seem to require a heightened standard. And the employees' arguments for a heightened standard, as Kavanaugh and the majority say, are um, are very policy laden. They're just saying, well, there's a public interest in a fair market with fair wages and whatever. It's like, okay, sure, accepting that for the sake of argument. Why does that mean that the statute requires a heightened standard? Like that just seems like a policy consideration that Congress could have written into the statute, but they didn't. Um, or well, the employers are at an advantage because they hold most of the cards, and they're more powerful and more resourced than the employees. Sure, again, a policy consideration that Congress could have written into the statute or could have considered and written into the statute a different standard of proof based on that policy consideration, but they didn't. They were silent as to the standard of proof. When Congress is silent, we sort of just presume that the default rule applies. The default rule here is preponderance. Always has been. So what are we doing here? uh yeah. As with the last few episodes, seems pretty straightforward. I expect most of the earlier cases in the term to seem pretty straightforward, be unanimous or near unanimous, with very little in the way of concurrences and dissents and whatnot, because well, straightforward opinions are easier and faster to write, so they get released faster and sooner. And you don't need, very much like writing of concurrences to add things or tweak things, sort of like what you see here with Gorsuch and Thomas, sort of saying, we understand things a little bit differently. But, in these cases, the issues are all relatively uncontroversial and straightforward. So, and sort of the last thing that I will say about this case is I think I sort of agree more with the concurrence by Thomas and Gorsuch um, as to kind of the understanding of how this should work, how courts should determine the applicable standard of proof. You start with the default rule, whether that's either preponderance of the evidence in most cases or some other default that has been established by the common law. Um, and then if the statute requires it, if the Constitution requires it, then, obviously you have to apply a heightened standard of proof there. But I don't necessarily agree with the majority's opinion. I shouldn't even say majority's opinion because it was a unanimous opinion. It was joined by the concurring justices, but I don't really agree with the main opinion and that sort of understanding of, well, but there's this third category of if the government is engaging in, particularly coercive action or whatever, then judges have to kind of, make up a standard of proof, or they have to impose a different standard of proof that seems kind of unmoored from any limiting principle to me, very policy based, sort of in the same vein of the arguments that the employees were making here. Um, or at least in a lot of cases, it will be sort of in the same vein as the arguments that the employees are making here. I tend to agree with Justices Thomas and Gorsuch here. Maybe if I thought about it more, considered it more, looked into, some of the case law on this more, then maybe I would find, my opinion would change, but that's sort of where I sit at the moment. But yeah, that's all I've got to say about this case for right now. So, if I may ask you, my friends on the other side of the screen, please like, share, and comment. Follow the podcast wherever you follow podcasts. And if you would like to support the podcast, you can do so on Patreon. The main content of the podcast will, of course, always remain free, but Patreon members have access to episodes early and to any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue our trek through the Supreme Court's 2024 term opinions. Until then.